too far from being live. So
I'm just going to wait until you say we're live, okay?
Yes. Please.
too far from being live. So
Ladies and gentlemen, we are now live.
So I'm just going to wait until you say we're live, okay?
We are live.
Please. Good morning, everyone. Can you hear me?
Yes.
Ladies and gentlemen, we are now live.
So I'm just going to wait until you say we're live, okay?
We are live.
Please. Good morning, everyone. Welcome all members of the Joint Committee on Federal Relations. I'm pleased to be joined today by Co-Chair Delegate Lily Chi. We have an ambitious agenda today. I'm very excited to see all of our colleagues here. I want to welcome all members of the Senate and thank you those that are here. I see Senator Jeff Waldstreicher. I see Senator C. Anthony Muse. And I also want to mention our other members because this is quite a large committee and hopefully they may join us later. Senator Jack Bailey, William Folden, Don Guile, J.B. Jennings, Cheryl Kagan, Karen Young. But for those of you that are here, we're thankful. The purpose of this committee is to monitor relations between state and federal government and look at also certain state issues. And to that end, we seek to gather information that could be important regarding congressional action as well as other federal government matters important to Maryland. And so we're excited today to be briefed by members of NCSL. And we have quite an ambitious agenda. And so I'm going to keep my comments very brief. But I do want to welcome everyone, and you should have had a copy of the agenda. I'm going to ask that you hold all questions until the end. We hope to end at 11:30. We are aware that following this presentation, we may also be briefed by the Governor's Office, the Director of Federal Affairs. I want to welcome Molly Ramsdell, Lauren Kalins, and Susan Parnas-Frederick. The topics today to be covered are the federal fiscal 2024 appropriations, the Farm Bill, the Secure and Fair Enforcement Regulation, Banking Act, Medicaid update, proposed nursing home standards, clean water and drinking water state revolving funds, and finally, Supreme Court of the United States update. And as I said, quite ambitious. So please listen to the presentations, hold questions to the end, raise your hand to be recognized, and please, if you are not speaking, mute yourself so as not to be disruptive to the presentations. And with that, I turn it over to Delegate Chief for opening remarks.
Oh, hi, good morning, everyone. Thank you so much, Senator Carter. I want to thank all of my colleagues for joining us this morning. I know everyone is very busy. I hope you have had a great interim so far and are ready for 2024. I'm very honored to co-chair this joint committee with Senator Carter. And I have served on this committee for, I think, only like a year before I was tapped to co-chair this. As you can imagine, a committee like this, which is called the Joint Committee on Federal Relations, could tap into many different subjects. So your input and your expectations are very important for our work going forward. We do want to hear from you as to how we want to focus our work so they can add value to your legislative work and bring back resources to your districts. So please remember, we keep our lines of communication open and tap into our great staff team, Scott Kennedy and Sam Quest and other wonderful staffers from the Department of Legislative Services. I want to just personally thank them for doing a tremendous job putting together this first briefing for our session. Today's topics were distilled down from the input of members as well as the leadership team of NCSL. So we're very grateful. They recommended these topics based on what they think would be most impactful and timely for the state of Maryland. So with that, the last thing I want to say is the recording of the session will be available to share, to watch afterwards. Oh, one final thing I forgot I should have mentioned at the beginning, which is I'm supposed to recognize the House members of this committee. I do want to mention Senators Karen Louise Young and Don Giles are present. They didn't just promise to come, they actually are here. So thank you. And then we have a larger House delegation here, which is delegates Mike Griffith, I see Griffin, I'm sorry, Delegate Matt Morgan, Delegate Bernice Miracle North of Montgomery County, Delegate, my colleague from ECM, Andre Johnson, and Delegate Julian Ivy. I also see Delegate Brian Chisholm. Did I miss anyone? Okay. Thank you, colleagues, for joining us. Let's roll. I'm going to turn it over to our leadership team of NCSL.
Great, thank you. I'm just first going to go, oops. Share my screen. Oh, let me just get these. One more thing. Let me get this 1 second. Hold on. And get this. All right. Can you hear me?
Hello. Here. I couldn't get off mute. So sorry about that.
All right. So good morning, and thank you, Chair Carter and Chair Chi, for the invitation to speak to the committee. As mentioned, I'm Molly Ramsdell, and I serve as Vice President of State Federal Relations for the National Conference of State Legislatures. It's especially nice for me to have this opportunity today to speak to the committee, as I also serve as NCSL's liaison to the Maryland General Assembly. So please don't hesitate to reach out to me anytime if I can be of assistance on state Fed issues or other issues of interest. I'm joined this morning by two of my colleagues, as was mentioned, Laura Callens and Susan Frederick, who are part of NCSL's state federal team in NCSL's Washington, D.C. office, where we really serve as your eyes, ears, voice, and eyes, ears, and voice of state legislatures before Congress, the administration, and the Supreme Court. That's the three of us across the top. And the others are the other faces of NCSL's state Fed team. As mentioned today, our agenda will touch on some of the federal issues we're following that we feel are of importance to states. Between the three of us, we'll talk for about 45 minutes. If there are other federal issues that we don't address today, we'd be happy to circle back with members with the appropriate member of the NCSL State Fed team. So let's get started. What is and isn't happening in Washington, D.C.? Now that the House has a speaker, congressional action has resumed, but it's really still too early to know if bills are going to actually get across the finish line. We have the current continuing resolution and several other policies and programs expiring on November 17th, and then other programs at the end of the calendar year, and we've listed a few here. There are also two supplemental funding requests, the one for $56 million in domestic funding, and a request for funding for the conflicts in Israel and Ukraine, Taiwan defense, and U.S. border security. With the House only having 20 workdays scheduled for the remainder of the year, the Senate has more in the range of 27 days. Time, as usual, is not a friend of Congress. We're going to dive a bit deeper on several of the items listed here, and let's go ahead and start with the CR. As I'm sure you're all aware, the federal government is currently operating under a continuing resolution that will expire in a little over 2 weeks. I wish I could tell you what will happen, but I can't. What I can tell you is it's really complicated. The new speaker said he wants to pass all 12 of the appropriations bills by November 17th. The House, I believe, has passed about 6 of them right now. The Senate hasn't passed anything, but is working on a minibus, an appropriations bill that would contain at least a smaller number of the appropriations bills. So we are definitely looking at another CR, continuing resolution, or again, a potential shutdown. It appears House Republicans will likely agree to a CR either to mid-January or mid-April to provide time for the House and Senate to come to agreement. However, some of the more conservative House Republicans want some conservative priorities to be attached to the CR, which means it's most likely not going to pass the Senate. Part of the challenge of getting any FY24 spending across the finish line is the different starting points in each chamber. And that really is what we call the 302B allocations. These are essentially the amounts allocated to each subcommittee, and they're shown on this slide here. The Senate started with 1.59 trillion in total, which was the number set in the Fiscal Responsibility Act enacted earlier this year. This was part of the agreement to raise the debt limit. The House saw that more as a ceiling and lowered their levels to about 1.4 trillion, which is more in line with FY22 spending levels. There appears to be some movement in the House that it will end up at a higher level, but how much higher, we don't know. And this really impacts the grants to state and local governments. It has been reported that enough House Republicans might be willing to adhere to the spending level set in the Fiscal Responsibility Act. I want to remind everyone that the Fiscal Responsibility Act includes a penalty for the use of a continuing resolution in FY 2024. It reduces both defense and non-defense funding levels by 1% if appropriations bills are not enacted by January. And this would take effect through a sequestration order to be issued by January 30th, 2024. I also just want to add that a similar penalty and timeline would apply in FY 2025. We're all going to be watching this very closely, and we'll keep you updated as things progress. Now let's move to the Farm Bill. The Farm Bill originally was set to expire October 1st at the end of the federal fiscal year. The CR extended the current authorization through the end of the calendar year. Here we are early November, 1st of November, and we still have not seen draft language from either chamber. House Republicans have suggested spending reforms that would hit two of Democrats' biggest priorities, funding the IRA climate agriculture programs and funding for nutrition programs. The new speaker has been on record supporting cuts to SNAP. The new speaker also said he'd like the House to pass a Farm Bill reauthorization in December. At the same time, members are asking for the extension to be part of the CR, just so members don't have to deal with another extension of the CR in December. What happens if they don't provide for an extension? Farm commodity programs would revert to permanent law from 1938 and 1949, impacting cotton, milk, wheat. So another extension at some point is almost guaranteed, but don't hold me to that. The question is now, how long an extension? As next year is an election year. There's some thought that if they can't come to agreement by the July 4th recess, excuse me, that it will have to be punted into the next Congress. Just an FYI, the Farm Bill is not often reauthorized in the year it expires. One exception was the most recent reauthorization of the Farm Bill. A few things to mention as part of the Farm Bill debate. Without a reauthorization, it likely means that the EATS Act is dead for now. EAT stands for the Ending Agriculture Trade Suppression. And this act would preempt state laws that regulate agriculture products sold or offered for sale in interstate commerce when those standards differ from federal laws or laws of other states. This was previously known, and you may have heard of the King Amendment. That's what it was called in previous Congresses. Earlier this year, the U.S. Supreme Court ruled to uphold California's Prop 12, addressing minimum farmed animal confinement standards. The EATS Act, would overturn California's Prop 12 and hundreds of other state laws. So something NCSL again is looking and tracking closely. One other thing I want to mention that was expected to be part of the Farm Bill negotiations in the House and is not going away is the Agriculture Labeling Uniformity Act. This bill prohibits any locality or state from imposing restrictions that are more restrictive than the federal labeling on a pesticide product. During the 2018 Farm Bill deliberations, similar efforts by the pesticide industry to limit state control were rejected by the Farm Bill Conference Committee. So again, something we're watching. Since the nutrition title of the Farm Bill is projected to account for about 84% this go around, my colleague Lauren is now going to update you on what's going on the nutrition programs. Lauren?
Thanks, Molly, and hello, everyone. I'm Lauren Callens. It's nice to see some familiar faces. I spent so many years, most of my professional career before coming to NCSL lobbying in front of you and your colleagues, so it's nice to be back. So I'm the legislative director at NCSL for Health and Human Services issues, and so I'm going to spend some time today doing a deeper dive on some federal HHS issues that I think will be of interest. As Molly mentioned, the Farm Bill's nutrition title includes SNAP, which stands for the Supplemental Nutrition Assistance Program, and it helps supports 42 million people across the country. That title also includes a number of smaller nutrition programs and is by far the largest title in the Farm Bill. It's projected this year to come in at $1.2 trillion, so it's under a lot of scrutiny. And while we fully anticipated that the Farm Bill was going to be held up this year, as it has in the past, by the nutrition title, many of us were a little bit surprised that SNAP was taken up during the debt ceiling negotiations, during which very significant changes were made to SNAP before the Farm Bill negotiations ever got started. Next slide, please. So, the debt ceiling agreement, formalized as the Fiscal Responsibility Act, both giveth and taketh away from the SNAP program. One of the biggest changes was made to SNAP's work requirements. Currently, the program limits able-bodied adults without dependents, called ABODs, who are ages 18 to 49 to 3 months of SNAP benefits during any 36-month period if they are unable to work or volunteer for at least 20 hours a week. The debt ceiling agreement increased the work requirement ages to those 50 to 54. Age 50 has already been phased in. Age 50 to 52 started in October, and by next fall, adults up to 54 will have to adhere to these new standards. However, the debt ceiling negotiations also included new categories of people who were at least temporarily exempted from the work requirements, and these include people experiencing homelessness, veterans, and youth ages 18 to 24 who have aged out of foster care. And the debt ceiling bill, in addition to these work requirement changes, also narrowed hardship exemptions, which takes away some flexibility for states. States use these exemptions at their discretion to convey an additional month of SNAP eligibility in certain situations, typically for vulnerable populations. For example, survivors of domestic violence or those with barriers to employment who are working fewer than 20 hours a week. That exemption is based on the state's total SNAP population, and it was 12%. Fiscal Responsibility Act reduced it to 8%. The act also narrowed the number of unused exemptions that can be carried over to next year. Next slide, please. So what was the impact of all these changes? Well, according to the Congressional Budget Office, these changes will slightly increase the number of people in the program over the next decade by 78,000, increase spending by over $2 billion over the next 10 years, and according to other estimates, put 750,000 adults across the country at risk for losing SNAP benefits. It remains to be seen what, if any, additional changes will be made to SNAP during the Farm Bill. As Molly mentioned, we have yet to see language. But just the debt ceiling changes alone will mean that states will have to change their screening processes in order to account for the new exemption categories and develop policies for determining homelessness. Some people cycle in and out of homelessness. There will be staffing issues. Computer systems will need to be updated. So there's a significant lift for states here. So the last thing I want to mention is the Maryland impact. In June of 2022, over 360,000 Marylanders were receiving SNAP benefits. And the Center for Budget and Policy Priorities estimates that based on numbers from 2019, that 15,000 of these Marylanders would be at risk for losing benefits once the changes are phased in. Again, just to be clear, not all will lose benefits. Some may qualify for these new exemptions, but there are roughly 15,000 that may be at risk. So before I turn you over to Susan for an update on the Safer Banking Act, I just want to mention another really important nutrition program that is being impacted by the authorization process. Next slide, please. So WIC is the supplemental nutrition program for women, infants, and children, and it supports roughly 7 million low-income pregnant, postpartum, and breastfeeding people, as well as children up to age 5, all of whom are at nutritional risk. This includes about half of all babies in the US, to give you some sense of the impact of this program. WIC enrollment had been declining pre-pandemic, but has been on the rise since the American Rescue Plan increased benefit levels and added program flexibilities, including the use of virtual tools that made it easier for people to navigate the eligibility process. And although the changes in the benefit amounts were made during the pandemic, they were consistent with the recommendations made by the National Academy of Sciences, Engineering, and Medicine in a 2017 report to Congress. And they include very specifically a significant recommendation, a recommendation for a significant increase in the amount of food funds provided for fruits and vegetables. The rising WIC enrollment numbers likely also reflect rising food costs, which we are all feeling, and the end of pandemic era emergency SNAP benefits, which in Maryland ended at the end of February. The numbers are rising so fast that it has caused some budgeting issues. When the Biden administration proposed its initial FY24 request for WIC, they requested $6.3 billion, which was an increase over last year, but turned out to be far below what is needed based on actual 2023 data. So to give you some sense of that, there was a 4.5% increase in the first 7 months of 2023 in WIC enrollment over last year. And this is what prompted the administration to subsequently request a supplemental budget for WIC of $1.4 billion. And while that was happening, the House advanced a bill that reduces funding for WIC and returns the fruit and vegetable benefit back to the pre-pandemic amount. So putting aside the matter of a government shutdown for a moment, without the additional $7.7 billion in funding, and some organizations anticipate that the number is actually higher, states may be forced to impose waiting lists and or scale back benefits. WIC is currently funded as a result of the last CR through the end of the calendar year, but WIC funding will stop beyond that if it is not included in another CR. Now, while states may use state funds to keep programs and services running, and many have and do and likely will, a full and timely reimbursement from the feds is not guaranteed. And this has the potential to impact around 123,000 WIC recipients in Maryland. Okay, I will now turn things over to Susan.
Thanks so much, Lauren, and thank you to the committee for having us here this morning. My name is Susan Parnas-Frederick. I'm Senior Federal Affairs Counsel for NCSL, and I'm going to take just a few moments to talk to you about the Secure and Fair Enforcement Regulation Banking Act, which is the SAFER Act. This is distinguished from the SAFE Banking Act, which has passed the House 7 times. The differences are primarily in the content of the bill, in the sense that the Safer Banking Act does not include expungement for past cannabis convictions, and it does not include some of the equity provisions that we've seen in the Safe Banking Act with respect to applications for dispensaries and regulatory affairs. So this actually, though, I have to say, the Safer Banking Act is the first non-research oriented cannabis bill to be in front of any chamber of Congress in 50 years. So it's a pretty big deal in the sense that this is an actual bill that's going to move the issue forward and not just set up a study commission or a research body to investigate and learn more about the issues related to cannabis. What the Safer Banking Act bill does, in a nutshell, is it allows banks to provide financial services to cannabis companies without fear of federal punishment. It did pass the Senate Banking Committee on September 27th, but it has not yet moved to the floor. On the Senate side, Leader Schumer wants to combine this bill with a separate cannabis expungement bill called the HOPE Act. Whether or not that will happen remains to be seen, given the sort of disarray that we find ourselves in with respect to Congress in the current time. There is no companion House bill either to safer banking. However, as I mentioned, the Safe Banking Act has passed the House many times. One of the standing controversial areas is Section 10 of the Safer Banking Act, which prohibits banking regulators from closing a suspicious account without a valid reason. And there's also notice and transparency requirements contained in the bill in this particular section as well. The idea of reputational risk is not a valid reason for a bank to close an account. So why is that controversial? Well, certain members on the Senate side are concerned that the bill doesn't do enough to protect other types of sellers, such as gun sellers and energy companies who face scrutiny in a Democratic administration. On the other side of the aisle, there is also blowback in the sense, as I mentioned, the equity issues and the decriminalization, which has been stripped from the Safer Banking Act. So if the bill does go to the floor, I anticipate that there will be a back and forth over the criminal justice reform piece and this notification piece and account closure piece. So that's the Safer Banking Act. I'm going to turn it back over to Lauren to talk more about some of the health and human services issues.
Great, thanks, Susan. So two other pretty significant things happening on the federal level. One, I just want to do a Medicaid snapshot, and then we're going to talk about some major nursing home staffing regulations, new rule that has been proposed. So I think probably most folks are aware that the continuous Medicaid enrollment mandate that existed during the pandemic ended on March 31st of this year. And re-enrollments for every state must be completed by May 31st of 2024. Maryland began its re-enrollment process in May, with letters going out in June. And nationally, since the mandate ended, over 9.5 million people have been disenrolled from Medicaid so far, 72% of whom whose enrollments were due to procedural reasons, a number much lower in Maryland. In Maryland, that percentage is 52% of disenrollments are due to procedural reasons, and 39% of these enrollments nationally are children. And just for some level setting, procedural disenrollments happen when people don't complete paperwork, either because they didn't understand it, they couldn't get through to a call center for assistance, they never received it because the state had outdated contact information, or because they were terminated by a state system that incorrectly determined what's called ex parte or automatic eligibility for an entire household rather than on an individual basis. And this latter reason, this systems issue, which impacted Maryland as well, resulted in 500,000 kids and others across the country losing coverage. In Maryland, as I mentioned, over 5,000 children under 19 may have been impacted, and CMS ordered all states, I think there are 39 of them, that people who lost coverage because of this automatic renewal process be immediately re-enrolled, and that these types of enrollments immediately pause until the state fixes the problem. So my understanding is that Maryland was scheduled to resume these disenrollments or the eligibility process again today. And I put some Maryland Medicaid numbers up on the slide as of September. You can see that as at the end of September, over 510,000 Marylanders had renewed their coverage, 128 had been disenrolled. Of those 128,000, 61,000 Marylanders were determined ineligible, and 67,000 were terminated for procedural reasons. So moving on, that was just a snapshot. Moving on, I want to talk about the regulations that CMS proposed and published early last month. And this is a rule that would impose minimum nurse staffing requirements for long-term care facilities that participate in Medicare and Medicaid. And among other things, the rule would require a registered nurse on duty 24/7, in addition to 0.55 hours of care per day per resident from an RN and 2.45 hours of care per resident per day from a nurse aide. The rule provides for staggered implementation between roughly 3 to 5 years, depending on whether a facility is located in a rural or non-rural location. And there is also an exemption process for states that can demonstrate good faith efforts to hire, but are located in an area, which is most of the country, where there are severe nursing shortages. Now, in the rule itself, CMS estimates that about 75% of nursing homes across the country would have to increase staffing in their facilities in order to comply with the new standards. And these standards exceed existing standards in nearly all states. Kaiser Family Foundation estimates that it's going to be 1 in 5 nursing homes that are not in compliance as of today. And the trade associations put that number even higher. The trade groups are also estimating that compliance with the rule will require the hiring of an additional 102,000 RNs and or nurse aides in the midst of a severe workforce shortage across several health settings that are all competing for the same workforce. Cost of implementation may be somewhere between $4 billion and $6.8 billion annually across the country, depending on whose numbers you use. And yet CMS is providing no additional funding short of $75 million in funding for a training program. In addition to the staffing requirements, states would also be subject to new reporting requirements on the amount of Medicaid funding spent on direct care wages and support staff. And states would also be required to stand up a publicly available dashboard with this information. No funding is provided for this aspect of the proposed rule either. The industry, not surprisingly, is warning of widespread exemptions, which at best undermine the intent of the rule, or scaled back admissions, closure of units, and or outright closures of nursing facilities at worst. Public comment is due on November 6th. And there are some in that little box. Sorry, had a lot to put on there. But Maryland has roughly 21,000 nursing home residents spread amongst 230 nursing homes. Okay, I'm going to turn things back over to Molly.
Thanks, Lauren. I was asked to talk a little bit about drinking water, the Drinking Water and Clean Water State Revolving Funds, or the SRFs for short. These programs are the 2 largest programs administered by the Environmental Protection Agency and the primary sources of federal funds for state and local water infrastructure. Changes were made to these programs in 2022 and 2023 that significantly reduced the amount to be allocated by individual states in each of these years. Congressional directed spending or earmarks were embedded in the appropriations bills for these programs. This slide illustrates those reductions, with the Clean Water SRF being the first 3 bars and the Drinking Water SRF the second 3 bars. While Maryland did receive some earmarks, their overall funding was less. I want to be clear, this does not include any COVID infrastructure related funding. As we head into FY 2024, earmarks are still in play. The House proposal cuts funding across both programs by 64%, with most of the reduction in the post-earmark amount. The Senate proposal level funds each program and reduces total earmarks by 60% more, leaving more for distribution to states by formula compared to FY 2023. NCSL has publicly urged Congress to appropriate the current authorized funding levels for the Clean Water and Drinking Water SRFs and exercises caution to Congress as it attaches congressionally directed spending to the SRFs. The Council of Infrastructure Financing Authorities estimates since the earmarks returned in FY 22, net federal funding for drinking water projects in Maryland, this would be the SRF plus the earmarks, declined by $7.6 million for clean water projects and more than $13.8 it was for drinking water, it was 7.6 million, and for clean water projects, more than 13.8 million. This is likely a trend that will continue, and I'd be happy to share that report with members of the committee. And with that, I'm going to hand it over to Susan to wrap things up with a SCOTUS update. And since Susan isn't using slides, I'm going to stop sharing my screen.
Thanks, Molly. Yeah, I don't have slides for this portion of the presentation. It's a lot of information. I'm going to just hit some of the biggest cases that the Supreme Court will be taking up in its current term. Some of the trends that we're seeing with the cases this term are similar to what we've seen in the past with this more conservative Supreme Court. So redistricting cases are front and center as well as First Amendment cases. And I'm going to hit on some of those as well as some additional cases that we're going to be hearing or have rulings on by the end of June 2024. So first, let's talk about redistricting. The case that is currently in front of the Supreme Court is the case of Alexander versus South Carolina State Conference of the NAACP. And this has to do with South Carolina's Congressional District 1, which was redrawn after the 2020 census. A 3-judge panel, however, found that the new map moved a significant number, which equated to 2/3 of the city of Charleston's Black population from District 1, which is currently represented by Republican Nancy Mace in the House, to District 6, which is currently represented by a Democrat, Representative Jim Clyburn. The map also moved Republican areas in nearby towns and cities of Beaufort, Berkeley, and Dorchester counties into District 1 from District 6. The Supreme Court noted that they did have jurisdiction to review the 3-judge panel ruling that a South Carolina congressional district is the product of an unconstitutional racial gerrymander. At oral argument, which happened recently, the state argued that the map was based on party, not on race. The Republican legislature's goal was to keep District 1 as a safe Republican district and had nothing to do with the racial composition of the district, which is actually permitted under redistricting laws. The NAACP argued that race was the motivating factor. So stay tuned for a decision there. This is coming on the heels of last term's Supreme Court decision in an Alabama redistricting case where the court said Alabama had racially gerrymandered its district. It needed to create a second Black district. They threw it back down to Alabama and chaos ensued. Moving on, though, we're going to now talk about some of the First Amendment cases that are in front of the court. And these two cases that I'm about to tell you about, there was oral argument on both of these cases yesterday. So the two cases involve social media and the First Amendment. The names of the cases are O'Connor-Ratcliffe versus Garner and Lindkey versus Freed. And the issues in both cases are very similar. The court will have to decide whether a public official violates the First Amendment by deleting or blocking comments from individuals from that official's personal social media account when the official uses the account to sometimes feature job issues and communicate about job-related matters with the public, but does not do so pursuant to any governmental authority or duty, which means there's no mandate from either the city or the state that the public official use that social media account for public purposes. So it does involve the First Amendment. In the first case of O'Connor-Ratcliffe, this is about two members of a California school district who were running for office, and they used personal and public Facebook and Twitter accounts to communicate with the public about official business matters related to the board and the district in which they served. The board members created the pages before they were elected, and they used them as campaign tools. However, they also had private social media accounts where they posted to family and friends. However, they also mingled those private posts on the public, or where they were also posting things that related to their jobs as supervisors. The Garniers, who are the respondents in this case, are parents of the children attending school in the school district where these two board members served. They criticized the board members' posts and responded with numerous, like in the hundreds, repetitive replies and comments. As a result, they were blocked and banned from the board members' social media accounts, and they sued the board under 42 United States Code Section 1983, claiming that blocking the comments constituted a state action under federal civil rights law that deprived the parents of their First Amendment freedom of speech rights. The district court in this case and the Ninth Circuit U.S. Court of Appeals agreed. So in the sister case of Linkey versus Freed, James Freed, who was a city manager, blocked respondent Linkey from his Facebook account and deleted his critical comments in the same manner of the California case. Freed, however, created his Facebook account as a college student and maintained it over the years as his personal account. Before he was hired as a city manager, he converted his personal Facebook account into a public figure page. He posted family pictures and events, as well as press releases and other information relevant to his job as a city manager. Linkey began criticizing Freed on his Facebook account and then began posting critical comments on his personal Facebook page. Freed first hid the replies, then ended up blocking the comments and deleting them entirely. As a result, Facebook deactivated and reactivated his page several times. So lots of back and forth with the platform. And Freed eventually decided to unpublish his page because he didn't feel as though he could manage the content well enough and didn't want to be in that mix. So Linkey also filed suit under Section 1983, alleging that Freed's deletion of his comments and subsequent blocking of his comments constituted state action and violated his First Amendment rights. Freed argued there was no state action. The Sixth Circuit Court of Appeals agreed that there was no state action. So what we have here is a traditional circuit split between the Ninth Circuit and the Sixth Circuit, which makes it ripe for Supreme Court consideration. So to note with these two cases, there's long-standing precedent that basically says if a government official is not engaged in official action, it cannot be held responsible or liable for violating a member of the public's First Amendment rights. So if you're not acting under color of state law, you have not violated anybody's rights by those actions. There are also prior cases that have defined what are considered to be a public forum and state action, although none directly address the question of how to evaluate these social media posts within this type of a framework. So what is the potential impact of these two cases? Fairly significant, given the rise and use of social media by many public officials across the country. At oral argument yesterday, the justices actually struggled to determine what the distinction should be between social media accounts used for personal use versus social media accounts used for professional purposes, and if or when it's okay to block critics without violating the First Amendment. I anticipate that the rulings in these two cases will really come down to the wire, and we shouldn't really be ready to look for them until June, the end of June, I would say. These are very complicated distinctions that the court is going to have to make. So those are the two most prominent and impactful First Amendment cases. Moving on to another line of cases that will have significant state impact, I'm going to tell you about Loper Bright Enterprises versus Raimondo. This is about the Chevron doctrine. And for those of you unfamiliar with what that is, in 1984, there was a big seminal case decided by the Supreme Court called Chevron versus Natural Resources Defense Council. And in that case, the court held that courts should defer to an agency's interpretation of an ambiguous statute as long as the agency's interpretation is reasonable. So that sets the stage for this current case. The Loper case involves an interesting statute that I personally have never had any interaction with. It is the Magnuson-Stevens Fishery Conservation and Management Act, which I'm just going to refer to as the Act. Congress enacted this statute after determining that there were overfishing concerns in fisheries off the coasts of the United States. And the statute designates the Secretary of Commerce and the National Marine Fisheries Service to develop a comprehensive fishery management program. Subsequently, the service did develop this program. And in that program, it required the Atlantic herring fishery to adopt an industry-funded monitoring program, which in turn requires fishing boats to pay for a monitor to ride along with the crew and oversee the actions to make sure that overfishing does not occur. The fisheries obviously objected, and their arguments are essentially economic ones. It's overly burdensome, it's cost inefficient, it's expensive. Some of the boats are really small, and to have, you know, additional non-crew members on the boats is not always feasible. And to the idea of the Chevron doctrine, they challenge the rule as being has exceeded its statutory authority, because the act does not specifically state that industry has to pay for the monitoring of the boats. So more importantly, an even bigger argument is they ask the court to overrule the Chevron doctrine, or in the alternative, hold that where a statute does not expressly provide for the specific power exercised by the agency, no statutory ambiguity exists and no agency deference should be provided. So pretty big deal. The lower courts, however, ruled in favor of the agency in this case, and it was appealed to the Supreme Court. I should note for you all that Justices Thomas and Gorsuch have criticized Chevron in the past. They have argued that giving the agency unfettered deference when a statute is ambiguous is akin to handing judicial interpretation over to the executive branch. And in order to reinforce that approach, 17 states have filed as amici in this case in support of the herring fishing companies, stating that historically courts have applied Chevron inconsistently, and the confused status quo has real costs for the people who live and work within our borders. Regulation is costly, overregulation, and mercurial regulation is even more so. So we will see how the court rules in this case, but it is a huge case. Agency deference impacts all the states. It impacts Maryland as well as every other state in the country in terms of how rules are to be applied and statutes are to be implemented across the board. So turning now to a tax case. This is an interesting one. I'm going to tell you about Moore versus United States, which involves a provision of the recently enacted 2017 Tax Cuts and Jobs Act, known as a mandatory repatriation tax. This is a provision that is a one-time tax that sought to obtain tax revenue on large earnings that companies held abroad, even if those earnings were reinvested into the company and the taxpayer did not receive any of the dividends. So the issue is whether the 16th Amendment authorizes Congress to tax unrealized sums without apportionment among the states. Under Article 1 of the Constitution, as originally ratified, Congress could only levy direct taxes if the taxes were apportioned among the states, meaning that the taxes had to be in proportion to the state population of that particular state. The 16th Amendment provides an exception to this requirement and permits Congress to tax incomes from whatever source derived without apportionment among the states. So in this case, a married couple owned a 13% stake in an Indian corporation that supplies affordable farming equipment to small farmers in poor regions of India. The corporation earned yearly profits, and this couple chose to reinvest their earnings into the business, and the business itself neither distributed dividends to shareholders nor received any income from their shares. In 2018, the Moores learned about the repatriation tax under the 2017 law, and they were told they needed to pay a one-time tax for the share of the company's lifetime earnings in the amount just shy of $15,000. They contend that this tax violates the 16th Amendment and that income must be distributed before it can be taxed. and therefore the mandatory repatriation tax is a direct tax not apportioned among the states. The Ninth Circuit Court of Appeals rejected that argument and ordered them to pay the tax. So now it is before the Supreme Court, and oral argument will be heard in this case on December 5th. Another important case involving guns and domestic violence, which has been written about a lot in mainstream media, is the case of United States versus Rahimi. And at issue in this case is whether Title 18, Section 922 of the United States Code, which prohibits the possession of firearms by persons subject to a domestic violence restraining order, violates a person's Second Amendment on its face. So the facts of this case are disturbing. Rahimi, who is the defendant, assaulted his girlfriend. He grabbed her wrist, he knocked her to the ground, he dragged her back to his car, he threw her back inside the car. She ran away. Rahimi then retrieved a gun and fired a shot into the air after seeing her fleeing. He called her after the incident occurred and told her that he would shoot her if she told anyone about what had happened. A few months later, Texas, where this took place, issued a domestic violence restraining order against Rahimi. While that order was still in effect, he became a suspect in a series of shootings. And upon searching his home, police found many different types of guns and ammunition. Rahimi pled guilty to violating a federal ban on the possession of a firearm while he was the subject of a domestic violence restraining order under the United States Code Title 18, Section 922. However, an intervening event occurred. The Fifth Circuit Court of Appeals upheld his conviction, but then the Supreme Court came in with a ruling in New York State Rifle and Pistol Association versus Bruin, which basically struck down New York's proper cause requirement as violating due process because it prevented law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment rights. So the Fifth Circuit, when it saw this holding from the Supreme Court, withdrew its former opinion and issued a new opinion vacating Rahimi's conviction. Under the Bruin standard, courts have to determine whether the Second Amendment's text covers an individual's conduct. And they said in this case it did not, because Rahimi, a restraining order is a civil matter, not a criminal one, and the Constitution presumptively protects conduct. The government has to justify the regulation by demonstrating that it's consistent with the nation's historical tradition of firearm regulation. So the Fifth Circuit also reasoned that Rahimi was still only a suspect in the shooting cases, and the domestic violence restraining order was not actually a conviction, but a civil matter. So this case is now up for grabs in the Supreme Court. Argument is set for just a few days away from now on November 7th. And I want to just briefly mention two additional cases to you that may become important for states that the court just accepted this past Monday. The first one is R.J. Reynolds Tobacco Company versus Bonta. And the issue is whether the Tobacco Control Act expressly preempts state and local laws that prohibit the sale of flavored tobacco products. So we shall see how that case plays out. It has not yet been scheduled. It was just granted review on Monday. And the second case is Hashim v. Cohen, which is whether a state controller's action under color of the California Unclaimed Property Law violates the due process clause of the 14th Amendment because it would deprive owners of their property without affording constitutionally adequate notice, and whether the controller's action under color of the law violates the takings clause of the Fifth Amendment because it takes private property without just compensation. Phew, okay, I am done. Thank you so much, and I'm happy to answer any questions about any of this.
Thank you so much, Molly, Susan, and Lauren. Before we go into your questions, if you don't mind, we're going to have a few minutes. We've got Matt Verghese, unless he's left. Are you still here, Matt? Oh yeah, there you are. We're just going to hear from him for a few minutes, and then we'll go into the questions. So Matt, you're on. He's the director of the Governor's Office of Federal Relations.
Great. Thank you, Chairwoman Carter and Chairwoman Shi, for inviting me here. Great to see all the members. As the Chairwoman said, I'm Matt Verghese. I'm the Governor's Director of Federal Relations. Some of you may have known me in my previous role when I was Chief of Staff to then Congressman Anthony Brown. Great to be in this new role. I'll be very, very brief. I apologize that I have to leave. I'm going to give you a little bit of inside information. The First Lady is expected to be in Maryland next week in Baltimore to talk about workforce development. So there's a call at 11 o'clock. I just want to kind of quickly just review what my office does, the ways that I can partner with all of you, and I'll make sure that I continue to attend these meetings in the future. The Federal Relations Office really is the governor and the state's main liaison to the White House and the Biden administration. We have a great friend in Tom Perez, who's the head of intergovernmental affairs there, as well as with the White House, with Congress, the Democratic leadership, as well as the Maryland congressional delegation, the National Governors Association, and a host of interstate or regional coalitions that we work with on a number of issues. Our goal really is not only to advance the governor's agenda, but really to make sure that we are maximizing the impact that the federal government has on Marylanders. And a lot of that is about protecting, securing federal funding, and maintaining an active role for Maryland in the national and regional decision-making process. So we're a small office, but we have a very large mandate. What I want to kind of take my couple minutes just to discuss, because I know this is top of mind for a lot of members of the committee, is just about federal funding. Over the last 10 months, I've received a number of requests, both from the leadership of the General Assembly, as well as members on this committee, about just the historic amount of funding that's coming from DC in this time, primarily through the Infrastructure and Jobs Act, as well as the Inflation Reduction Act, which is really making historic investments in climate and transportation. And one of my primary goals is to ensure that we are maximizing that funding. Well, the governor has stood up in his first 100 days for the first time here in Maryland is something that we call the Federal Investment Team. So essentially, it's an interagency group across the entire state government solely dedicated towards pursuing, applying, and then actually winning federal discretionary competitive grants. So we stood that up with one liaison from every major department and agency. And I'm glad to say that since we stood that kind of federal investment team up in March of 2023, we have secured almost $6 billion in federal competitive grants. And that's really just because we are working more collaboratively, and we have an excellent relationship, not only with the Biden White House, but also with our congressional delegation, who is also advocating on our behalf. The FIT, as we call it, is really a centralized structure that meets twice a month and allows for more collaboration across agencies and make sure that our grant applications are as competitive as possible. And really, we are working to make sure that even for grants where the state is not the primary person who's applying for it, we're supporting our Maryland counties and municipalities, as well as sometimes some Maryland private companies. And one of the big wins that we just had recently was the designation of the city of Baltimore and a wide coalition led by the Greater Baltimore Committee for the Baltimore Tech Hub that make them eligible not only for up to $50 million in federal grants in the short term, but several $100 million more in the long term. By that builds on success that we work with many of you in your communities, including $20 million for a new transit hub project in Mondawmin in Baltimore City, a new trail project in Prince George's County, $11 million for the Port of Baltimore, and more than $9 million to finally connect the Penn and Camden lines for our commuter rail. So a lot of money coming from DC and a lot of projects that we are working with in order so that we can compete for them successfully. Really, my goal in my office and with my team is to make sure that we are identifying projects that the state can compete in, that counties can't compete in, and then work with you to make sure that we're writing the right grant application and showing the wide community support in order to win some of this money. And so my commitment to you is not only to continue to work with all of you in the months and years going forward, but also to have an open door policy if you want more information about grants, have questions about what things we're applying for, how you and your constituents can be better plugged in. So I appreciate the time today, and I know I have to run today, but I'll make sure that I share my contact information with the staff, and all of you will know how to reach me. Thank you so much.
Thank you, Matt. I understand you don't have time to take questions, but you'll leave your information. Okay, Senator Kagan says she has a very quick question.
Matt,
Of
it's always
course.
great to see you. Thank you, thank you. And I know you have like 60 seconds here. I just want to, in this group, just mention the hostages in Gaza. I want to thank you for your leadership, and I wonder if you can offer a brief update as to how you're working with the White House to save Marylanders and relatives of Marylanders who were kidnapped from Israel.
Absolutely, Senator, and just a tragic situation. While we've heard some positive news about less than half a dozen hostages that have been released or have been saved, there's more than 200 that have still been unaccounted for. We're on daily calls with Marylanders or people who have family who are among the hostages there about the progress of the military kind of incursion into Gaza, the plans where if they know that they've been in contact. Unfortunately, Hamas is a decentralized type of system, and while we are, the government, the Biden administration is working with Qatar and a number of Gulf countries to try to work with certain kind of sects, there isn't like a cohesive approach in kind of working with hostage taker by hostage taker. It is really a horrible situation. What the Biden administration is committed to is that they're going to continue to work tirelessly. They have been in constant touch with the families. As much information as they receive on the ground, they're relaying that back to the families. The best that we can do is continue to keep the pressure up and to make sure that these families know that we are constantly thinking about them, doing everything that we can. And again, I think the best thing we can do is information right now, ma'am.
Agreed. Matt, thank you for all you do. Good to see you. Good luck.
Absolutely. Great
Thank
seeing
you,
everyone.
Madam Chair. Bye. Madam Chair, thank you very much for letting me squeeze in.
Thank you so much. All right, questions for our NCSL presenters? Anyone? Well, I will say the presentations were very thorough. I particularly appreciated the Supreme Court updates. Susan, thank you for that really valuable information. And I think for many of us, some of those issues really, really pertain to us, especially the domestic violence gun case is very interesting, as well as the social media, which frankly, I'm already thinking about changing my social media now. Delegate Tolles, you have a question for one of the presenters?
Yes, thank you so much, Chair Carter. I am too intrigued regarding the Supreme Court cases, and I don't know if someone from the Assembly is here. They kind of talk more about what we can look forward to as it relates to the gun case, because we know we had recently one portion of Bruin was challenged and was overturned. So some portions of what we passed, I think with SB 1, was overturned. And so I wanted to talk about how that could tie in to that domestic violence, I guess, case. Trying to understand my handwriting. The Remni. Sorry, I can't understand. Rahimi, thank you. I'm like, what? That was the H I wrote down. Okay. But if you could talk about that, I'm really, interested in terms of that particular case, ruling, and then how that would tie into what we've seen recently here in Maryland. And I'm a member of the judiciary, so obviously I'm really concerned with how we would move forward this session in committee.
Well, thank you for the question, Delegate Tolles. I will try to answer as best I can without having my crystal ball working on November 1. But I can say that what the court is going to have to determine is how broadly is Bruin going to apply to this new set of facts. Bruin applied to a case where gun owners had to have a special permit under New York law to conceal and carry. This case doesn't necessarily involve the conceal and carry component, but what it does involve is a civil order versus a criminal conviction. And I think that's where the court is going to have to make their bright line distinction. Does the Constitution or how are we going to look at something like a domestic restraining order, domestic violence restraining order, which I would argue is perhaps quasi criminal in nature because there's obviously a reason for that domestic violence restraining order to have been issued. And is it an aspect of public safety to restrict the person who's the subject of that order from having and owning a firearm during the time period that's been set in that restraining order? So the court's going to have to determine how broadly to apply the Second Amendment. Which is it going to be? Domestic violence will trump Second Amendment, or Second Amendment rights are so broad that it won't matter if there's no criminal conviction that would otherwise prohibit someone from owning a gun.
No, thank you for that. Because we had lots of discussion, not only with SB1, but with and I might lean on to Chair Carter to help me out. Luke Klimpecher's bill. Was that HB 87? 87. But you know which bill I'm referring to. Chair Carter is on the JPR, so we often, as well as Senator Meese, tag team on some of these issues. But lots of discussion was had in my committee regarding, not only restricting, gun use for the individual who the restraining order is against, but also having the ability for, the victim or the one that's being perpetrated to have access to a firearm. And oftentimes with restraining orders, they kind of file on each other. So you file one on me, I'm gonna file one on you. And so really interested in what's going to happen here, because there was, like I said, lots of discussion regarding protection for those who, were being, for victims to have protection for themselves as well. And so they may have a restraining order of them, and so how that will protect them as well going forward. So now maybe we have to wait for another year to see what happens, but curious nonetheless. So thank you for bringing those topics and all of those sort of judiciary discussions forward with this body. So thank you.
You're very welcome.
I see no other hands. Oh, Delegate Chi. Well, I
All
won't. You can call on yourself, Delegate Chi.
I want to follow the protocol because we have quite a few members here. Seeing no other hands, I just thought I would pop in my own question because I serve on House Economic Matters Committee, and last year we did a heavy lift, both chambers, in passing the Cannabis Reform Bill. And I heard you mention something about the Safe Banking Act, and then there's the Safer Banking Act. I was trying to take some notes, but I would appreciate a bit more clarification, because each of you did a very thorough job, but also went very fast. I'm trying to understand which one speaks to, removing the penalty for the states in funding those startups, because it's already a very high threshold for people to get into that business, and access to capital continues to be an equity issue for a lot of minority businesses, especially. So could you elaborate a bit on that, please?
Sure. So the Safe Banking Act, which is the version that's passed in the House, that version had those economic provisions in them on the equity side. So that's the more expansive version of this particular type of legislation. In the Senate, in order to even get it through the committee, the equity provisions needed to be stripped out of the bill. And it's a straight up banking bill. I don't know that those provisions will necessarily come back in on the Senate side, but the way it's being sort of shopped out by Leader Schumer and those that support it is that it is a first step toward, legalizing this type of business, and that, let's get the banking bill in place and allow dispensaries that already exist in legal states, both medical and or recreational adult use, to be able to put their money in a federally insured bank, as opposed to, putting it under the mattress, having it be a cash only business. And let's, remove some of those public safety concerns that we are hearing about with respect to the way things currently are right now. So that was sort of the motivation behind that. And in order to reach the compromise position in the Senate, some of those provisions, descheduling had to be removed. The equity provisions had to be removed, but that doesn't mean you can't do that. If this were to pass, it's not preempting states from putting in equity provision state law. So if you're a legal state, which you are, you can regulate it and you can put those conditions in. I just don't know that there's any federal money behind that to help in that instance.
Thank you.
Thank you. Questions from members? Going once, going twice. I don't want to close. Delegate Tolles?
I just had a follow-up. Thank you, Madam Chair. If Susan, if you could email or provide us those cases that you indicated during your speech.
Yes, ma'am.
Thank you so much.
Delegate Morgan?
Thank you, Madam Chair. I had more of a question for the committee and the co-chairs at the end. So I don't know if that's appropriate right now if we're getting ready to wind down. Just make that announcement.
Yeah, seeing no more questions from members, then I think that we can, entertain your question at this point. I want to thank our presenters, though. Very, very, very useful information, and we really appreciate that update.
Thank you, Madam Chairs. I would like for this committee to reach out maybe to somebody at Homeland Security and see if we can get a briefing from Homeland Security. With so many people, we've had over 9 million illegal aliens cross the border. We have a huge fentanyl price problem. Along with that illegal immigration crossing the border, we've also had some issues with human trafficking. And now that we've had the events unfold over in Israel, I think there's some bills that are coming up this year that would really benefit ourselves and our colleague if we could get some type of security briefing from Homeland Security. I've been told that they're willing to do something like that. That's not something they customarily do, is inform legislators. It's something we probably have to ask for since it's not really in their mission statement. But if somebody from the federal government would like to maybe enlighten us on some stuff that we don't really know and get the facts instead of just getting media coverage, I think it would be beneficial for everyone in the General Assembly. Thank you.
Thank you, Delegate Morgan. I appreciate that. And I think that those are important topics. I believe that Delegate Chi and I have talked with staff about possibly having a follow-up briefing somewhere around the beginning of session. And so I would welcome that suggestion, as well as any suggestions from the rest of members as to what you are interested in. And we're still testing the waters in terms of being able to ascertain what our scope is and what our bandwidth is and what, if any, restrictions there are on what we can do. But we're happy to reach out because I think it's important that we utilize our access and our ability to get information to benefit all of our members. So the answer is absolutely, and please, we invite more suggestions. Delegate Chi, did you have any?
Yeah, on that note, and we always appreciate the input and suggestions because, as I said at the beginning, for a joint committee on federal relations, it could be just about anything we want to be briefed on and connected with, right? And also, in our consultation with each other about what to focus on, we actually, the two of us, Senator Carter and I, already sent a letter to our federal delegation introducing ourselves and the existence of this committee and expressing our desire to be better connected. Instead of us defining the scope, we could seek input from our very capable federal delegation to say, let us know how we can be a better and effective partner at the state level, because they represent us, So yeah, feel free to let us know how we can represent you and your interests as well in connecting with them.
Any other questions, comments, suggestions from members? Well, on that note, is there a motion that we adjourn?
Yeah, I just wanted to mention, first of all, beyond the thank you and then the Madam Co-Chair and all the members, including I see later and the Senator Cheryl Kagan also joined, and I'm sorry, Delegate Karen Tolles, I forgot to mention you at the beginning of my intro. I just want to thank everyone for taking the time to join us, and also thank again the very capable and efficient, I can tell, very well prepared presentations from NCSL tailored to the state of Maryland. The recording is available for you to share and rewatch if necessary. We will be happy to share the contact information of Molly, Lauren, and Susan if you want to follow up directly with them, and as well as the slides. So that's it. Thank you.
I thank all members, and once again, I'd reiterate, some of the most efficient and conscientious staff, Scott Kennedy and Sam Cleese, we really thank you for all that you do. Nothing would be possible without you. And with that, a motion that we adjourn?
So moved.
So moved.
When is the next
Second.
meeting? Is it again in 2 weeks or how do
We
you?
don't have a scheduled next briefing. We're gonna try to pull members and look at the schedule, but we thought sometime around the beginning of session, since we're all ostensibly here.
Thank you.
Thanks, everyone.
Thank you.
Good to see you all. Bye, Lauren.
So-
Molly.
Have a good day.